I believe Mr. Willis has something he wants to say to you.
Oh, Lord. All right, Mr. Willis, what you got you want to say to me, sir?
I've been trying to get this case situated. Ms. Hahn she's had my case since April. She said she's done nothing. I don't even have my discovery. I went to the office twice and we're bumping heads. I didn't tell her I didn't want her on my case, but she told me our phone call yesterday was Sunday was real crazy. She told me that she could fire me. So, I mean, and given what this is, I feel like I'm just dealing with the prosecution on all sides around me. And I don't feel that I have anybody in my corner that's going to defend me properly. And she said that she could fire me. That just shows that we're not working good. I said a prayer to calm her nerves on the phone. She had just been to the hospital and she hung up the phone on me. So, I mean, I know that she said that they're a pro bono private firm or whatnot, but she would like to she expressed that she would like to step down, and I just would like to get whatever discovery that she has done at this point, if I could receive that from her. And then I guess she would like to go about her way. Can the court put somebody else in her place?
All right, let me hear from Ms. Hahn.
Your Honor, I think there's been some miscommunication. I did explain to Mr. Willis that the relationship is not entirely one-sided, that if they're, I'm trying to say this carefully, but if need be, that we do reserve the right to withdraw. I obviously could not do that unilaterally. I would need permission from partners. However, that's not the case at this time. We still represent Mr. Willis, and we are doing so to the best of our ability. We recently filed entry in the case, and we have the report, and I believe Ms. Arnold will be sending discovery, and I did indicate to Mr. Willis that I would bring that discovery to the jail today. So I would bring a hard copy to him. However, if Mr. Willis is of the mind as well that he would like new representation, Your Honor, I think that he should do what's in the best of his.
Let me ask one crucial question.
Sure.
Why is Mr. Willis still in jail?
Your Honor, Mr. Willis was released. We did a motion to modify bond in which Your Honor released Mr. Willis on an unsecured judicial release after he had been severely injured inside the jail. And then he did recently get picked up on new charges. So that's why he's there currently.
What are the new charges?
Your Honor, I believe they're going to Superior Court.
Okay, so Mr. Willis, because what you're telling me is not unusual. Listen to me.
Okay, I was telling you about the charge. I thought.
No, I don't want to know about those charges. I just want to know that they're not my charges.
Okay.
As long as they're not mine, I don't care about them. But what I will say is you were out on bond. Because you were out on bond, your case is going to move a little slower than if you're in an active inmate. That's just the nature of it. I have to try active inmate cases first. Had you still been in jail, then your case would have moved a little faster, and we probably would have had you on a trial calendar already. Number one. Number two, it is not unusual for discovery to take this long. Not that the solicitors aren't sending the discovery, not that they're not receiving the discovery, but it's not unusual. There are a lot of cases, a lot of things have to be done in sequence. So the discovery has to be requested and then it has to be sent. This is a 2023 case. So it's not any slower than any other 2023 case. You are back in jail on something else. So the way this case has progressed is as if you were out on bond and you can work from outside the confines of jail. So whatever got you back in jail, that's on you, sir. That has nothing to do with Ms. Hahn or this case. But what I will say is that I don't find that anything is wrong with the way that the case is being handled as far as discovery. If she has the discovery, you can talk to her about it, but there's been no delay as I can perceive.
Judge, this was saying where I got this battery for, these are old cases. This case is like a year old. It's just that
And that's not old in court. That's not old here.
they keep bringing back.
I have cases, I have 2020s, 2021s, 2022s. So I actually don't have any 2020s, but I have 2021s and 2022s. So this is not an old case that you perceive it to be because you're in jail, but it is not an old case as far as how we're moving cases.
Well,
So it's not going to gain you anything to fuss with Ms. Hahn.
I'm not
She knows
fussing-
what
I'm
she's
fussing
doing.
her. I'm
If
just-
you
I just-
If you want me to appoint another attorney, that's going to start the clock all over again and you're going to be back to square one. Do you want to go back to square one?
I don't, but she's not giving me the proper defense, and
No, she's
not
not
defending.
telling you what you want her to say, but she's a trained attorney. Maybe what you want her to say is not the proper defense that she can bring before a court. Number one, she's not going to suborn perjury, which means she's not going to lie for you, or she's not going to encourage you to lie or anybody else to lie. Number one. Number two, if it's a defense that will not work for your case, she's not going to push it because she's, listen to me. She's the attorney. You're not. So, Mr. Willis, if what you're asking her to do does not make legal sense, then she's not going to do it. So a lot of times people get into jail and they hear, Mr. Willis, you listening to me?
Yeah,
A lot of times people go to jail and they have jailhouse lawyers who telling them how things should go, but a jailhouse lawyer is still in what? Jail. And if they were a smart person who went to law school, they wouldn't be in jail. So what I'm saying to you is whatever Ms. Hahn is telling you, she's managed hundreds of cases before me over the course of the last 2 years that she's been in front of me. And I have not found her to be insufficient in any way in the way she handles legal matters. So if Ms. Hahn is telling you that something is not going to work and you're pushing it, I'm telling you, she's probably right, that it's legally either something that's unethical, illegal, or that's going to tank your case.
Mr. White, I'm sorry, Judge. I didn't ask her to do anything unethical. I asked her for my discovery. And I don't know the law, but I researched it. Now, all I'm saying is that if I have somebody that sit here and say they don't want to defend me,
it's not a matter of not wanting to defend you. She says she has your discovery. She can go over it with you.
I don't want to go back and forth with you because this is your courtroom.
But you're not going back and forth with me, sir. What I'm telling you is she has the discovery. She can go over it with you. But you're not going to tell her how the case should be managed because you're not the lawyer.
I haven't told her anything how the case managed. I just asked her what has she done on the case. I haven't even talked to her. I haven't seen Ms. Hahn since the last time she came in on May 15th. Ever since then, she's been very inactive or out of service, out of commission. All lawyers are. No lawyer.
Ms. Hahn, when did Mr. Willis get back in the jail?
August 11th. They held me.
We met on Friday and on Sunday briefly, but very briefly, the conversation.
She said, when I get back in jail,
Sure.
August 11th, 2020.
Okay. All right. So, Mr. Willis, from your standpoint, what is it you think should be happening in your case right now?
I think they should look at the distracted driving charge that we have in this courtroom because that was vindictive.
Mr. Willis, that distracted driving just means you had something in your hands while you were driving. Do you want to offer on that case right now? Because that's not why you're in jail.
I would like an offer on that case. I think I should.
All right. What's the offer on distracted driving, Ms. Janvier?
$50.
Okay, $50, $83.25 with the surcharges. Would you accept jail time instead of the $50, Ms. Janvier?
Yes.
All right. So you want 1 day jail time. Okay, is that good?
Yes, ma'am.
All right. So then we can get rid of the distracted driving today. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
It is.
All right. You can put your hand down. You're before the court on 2022 CR 01125. You're before the court on distracted driving. You're entering a plea of guilty. The fine is $50. By doing so, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
I'm from America. Yes, ma'am.
All right. So the distracted driving, it's a guilty plea, $50 fine. In lieu of the fine, the court will accept credit for time served 1 day. All right, that case is over, sir. Now, did you have anything else?
Yes, with the battery, they got me on battery family violence, battery again, battery simple family violence.
Yes.
It has to be, how do I, is one of them gone for battery?
No. So let me explain to you what happens. So when you get picked up by the police will charge you with battery and maybe family, then you might get 2 charges. When the case goes to the solicitor's office and they look at the facts as presented by the police and the investigation that they conduct, there may be other charges they want to bring, which gives them the ability to prosecute the case fully, so that if they went to trial and you got found guilty on, you got acquitted on one charge, you may get found guilty on a different version of the charge. So they'll bring as many versions of the charge as they think will fit the facts of the case. Now, then when you go to trial, some of those charges may merge with others, meaning that they'll be treated the same as others for the benefit of trial and sentencing.
Okay. Well, I got I mean, I guess the next step in the case will be, what is this point for the other, since the other file is gone?
The next step in the case would be to go to trial. So if Ms. Hahn now has the discovery, she can talk to you about it. You'll get together and go over the discovery and prepare for trial. But please understand, if you are proposing a legal defense that does not work or that is not proper, she's not going to present it.
I haven't talked to her about the legal defense, but I know the prosecution has, they don't have a witness. I know that
Okay, so first of all, you need to stop talking, because if you know anything about the witness in this case, then that means you may have violated your bond conditions and had contact with that witness. And if you violated your bond conditions and had contact, then you're going to stay in jail. Your bond might be revoked and you might be charged with additional misdemeanors or felonies. If you have had any contact with with the person listed on your bond conditions who may be a witness in this case, you could also be charged with jury tampering, as well as aggravated stalking, which is punishable by 10 years in prison, a $10,000 fine, or both. So for you to tell me that you know there's not a witness means that you have had some contact with that person that could be criminal in nature.
I've had no contact with.
All right, so then stop talking. What I'm saying to you is you need to discuss the case with Ms. Hahn.
Okay. No, I'm saying
when she brings the discovery to you, respect her as the legal professional that she is. She went to school for 3 years for this. She ain't just pick up a book and one day decide she was going to be a lawyer. She's been practicing before me at least 2 years.
I respect her. I'm not disrespectful. That's the narrative that's being pushed in this courtroom. That's false. All the video calls are recorded, and that's it. We can pull those, and Ms. Hahn will know that. I don't respect women. I mean, I don't disrespect women. I'm a Christian man. Only thing I did was pray. Now, if she felt some type of way, if that version of her felt some type of way about that, that's on her. If I could, I would have started this meeting with prayer first, man. I did prayer call before I went to bed last night. So if that's offensive, if my religion is offensive and who I pray is offensive, then that's discrimination against me, against race, creed, and religious affiliation. I haven't disrespected her at all.
All right. Well, she's going to discuss with you the discovery in this case. Your case is going to go on a future trial calendar. It is not on this calendar, but as an active inmate, your case takes priority. So she's going to discuss it with you.
Fair and speedy, that's 100 days, right? I read that.
You know, it's not a speedy, sir. You're just an active inmate. Your case goes to the top of the list because you're an active inmate. But please understand, sir, that you're not in jail for this case.
No, I know. I'm in jail for something else, but
Okay.
they don't give me those. They keep pulling these warrants back up. They just like to keep me in their facility. It's almost intimidation. But
Okay, sir. Well,
Your
for
Honor.
whatever reason, Mr. Willis, you're in jail. So we're gonna move your case as we would any other active inmate. Ms. Hahn is gonna meet with you, and then you all will announce ready for trial and be ready to go forward.
All right, it's Ms. Hahn, you're coming in person so that I could touch the tangible documents you have, right? And get a copy of those from you?
Mr. Willis, I will bring discovery to you so that you can have a copy.
Also, Your Honor, I did want to know that we're back here on Thursday with the motion to revoke bond for Mr.
All right. Oh,
Willis.
Mr. Willis, you're also on a motion to revoke bond, so we'll see you on Thursday for that.
Do I have to be present for that? They're gonna revoke it anyway. I mean, you know how this jail move. Do I have to come back from there? That story.
I would advise you to, because I don't want you saying anything wrong that Ms. Hahn did. So you're gonna be present for that, because you're not gonna come in here and say that Ms. Hahn did anything wrong.
That's gonna knock my noodles out though. I need my noodles and I need my store there. And it's at 2 p.m. You know,
It's gonna knock your what out?
it's gonna knock my noodles out. My noodles and my stuff that I got coming store. They only do it one time around here. She's still talking to me.
Mr. Willis.
They still only do it one time. When they bring store here,
Mr. Willis.
Uh-huh.
she's listening to me.
Coming up here Thursday,
I
okay?
just-
Ms. Deputy Jones?
Yeah, can I be excused from it Thursday? Because it's not nothing important and nobody's disrespecting Ms. Hahn. I don't need another narrative. I don't want to be on camera no more unless my case is fully getting dealt with. And please, that's my happy place. I like to read my Bible while I make me a Cajun shrimp noodle with some hot barbecue chips in there. That's my happy place right now.
All right. Ms. Hahn, your client is asking to have his appearance waived for the motion on Thursday. Do you agree to have him waive?
Your Honor,
What's the waiver do?
Hold on, Mr. Willis. That's the way that's the technical language. It's a waiving your appearance. All right, so stop talking, sir.
Okay, my bad.
All right, go ahead, Ms. Hahn.
Your Honor, I would have liked to discuss the motion with him. However, since he's adamant that he would like to waive his appearance, then Your Honor, that's fine.
All right, so
Can she discuss it when she comes up here and then we can waive it before Thursday? That makes more sense to me.
And Mr. Willis, I'll just be dropping off the discovery this evening in prep, because I have to prepare for my calendar tomorrow, but I will schedule a time to meet with you and we can go over the discovery and preparation for trial. However, but I will make sure that you have your paper discovery today so that you can look at it privately and prepare any questions that you have for me about it as we prepare for trial.
Thank you.
all right, yeah, Mr. Willis, you have to understand too, she's got a calendar before me tomorrow. She's got a calendar before me Thursday. So she's got cases on both of those calendars that she's got to prepare for. So give her some space to prepare for those, but she's going to drop off your papers that you can look at and make notes on until you meet with her, okay?
All right, thank you very much.
All right, and because you want to waive your appearance on Thursday, and it's on the record, so the court will allow you to not appear on Thursday, but the court will proceed with the motion to revoke bond. You understand that?
I understand. I don't need to be here to get beheaded. I don't need me here for that.
All right then. Thank you, Mr. Willis.
Thank you, Your Honor.
All right. All right, so that concludes the calendar call, thank the Lord. And we have the